acting Denel CEO Talib Sadiq has disputed claims by witnesses that the payment of 12.7 million to LMT Holdings was to assist the company deal with its financial difficulties. The state capture inquiry heard this week that money from the arms company was used to bail out one of its suppliers. LMT Holdings received early payment for the supply of armored vehicles to Denel. The company was facing financial difficulties at the time. Denel also allegedly took a decision to purchase LMT shares to ensure the company's survival.
Chair, there were a combination of issues around LMT, and LMT has a point out in paragraph 2.14, what caused us to go ahead. One of the issues was the financial challenges that the company was facing. But the important thing is that they were the localized partner of an international OEM called Patria. And we had then placed a contract on them called a Trunnion contract. And on that contract, we had paid 25% of that Trunnion contract as an advance payment.
Yes. But are the other witnesses correct to the effect that if you had simply followed the letter of the contract between DLS and LMT, you were not due to make that payment, but this was, as it were, a concession to LMT. It was a way of assisting them to get an advance payment which they weren't contractually entitled to, but which you were persuaded to pay in order primarily to assist them in a situation of financial difficulty.
Chair, when we place a contract, we normally will pay a supplier an advance payment, which is generally about 25% of the contract value. So it's on that basis we made so it was part of our normal course of business to make a portion of the prepayment, especially when a contract is quite material.
Former President Jacob Zuma has filed an application for State Capture Inquiry Chair Justice Zondo to recuse himself. It comes after a letter was written by the Commission Secretary, Professor Itumeleng Mosala, to Zuma's lawyer, Advocate Eric Mabuza. Mosala, in the document, asks whether Zuma will be honoring his scheduled appearance at the Commission on Monday. Well, let's make sense of the legal issues that are at play. We're joined by Advocate Mudidima Manya and Attorney Marius du Toit. Thank you both for your time tonight. Let me begin with you, Advocate Mudidima. Firstly, this back and forth that is taking place between the Commission's lawyers and the lawyers for the former president, beyond the legal battles that are now taking place, do you foresee any way that it could now be settled out of court effectively, for lack of a better phrase?
Well, look, I thought there's and good evening to you and your listeners. I thought there's actually a mechanism. The issue around the Deputy Chief Justice is about a personal issue. I'm not sure whether it changes the evidence that has been given by witnesses. And I thought if I was the president, I would appoint another judge just to focus on the evidence of Mr. Zuma. I'm not sure whether it is going to change the evidence and the facts. So that is another option available to diffuse this situation. But I think we must be very careful as well. And the question is whether Mr. Former President Zuma is in fact entitled to a recusal. And that is a matter that Deputy Chief Justice insists with to decide.
Attorney Marius, who exactly is going to make the call on the recusal application? Will it be up to the DSJ to decide if in fact he's going to step down because he feels conflicted or not?
Well, essentially, when a presiding officer realizes that he's conflicted, he should immediately recuse himself from the proceedings. If he doesn't believe that he's conflicted or that he's biased or anything to that effect, then, of course, the party who feels aggrieved by this presiding officer presiding over the proceedings, then has to bring an application before that very same presiding officer. And he has to then say to him, well, listen, I have a reasonable apprehension that you are biased. And then, based on that, the presiding officer must then make a ruling and say, well, I'm not. Or he must try and divorce himself from the proceedings and see objectively, well, listen, am I conflicted to hear this matter? And if he, of course, says, no, I'm not, well, then it opens the avenue for that decision that's been taken to take it on review to the High Court, and then have the High Court ultimately decide whether I'm in fact conflicted or not.
Advocate Madidima, what is the test? What is the test for, a conflict of interest, especially in the case that we're dealing with? In responding to some of the allegations that had been leveled by the former president, Deputy Chief Justice Raymond Zondo has said, well, I do have connections with Zuma due to having fathered a child with what would then be his wife's sister-in-law, his wife's sister rather. But he doesn't see that connection as having been far enough to actually result in a conflict.
Yes, the Constitutional Court in 1998, in the matter, the famous matter of Mr. Louis Late, who took the president to court, and the President Mandela then was brought to court to give oral evidence. When the matter went to the Constitutional Court, Mr. Late, in fact, applied for the entire bench of the Constitutional Court, which is 10 judges, to all recuse themselves. One of the issues he raised was that the then president of the Constitutional Court, Justice Arthur Chaskalson, had served as an advisor to the ANC. He claimed a personal relationship. And the court, in dealing with the matter, said that whatever happens, there has to be a relevance to what is being decided upon. Now, I'm not sure, again, I haven't seen the application itself, but based on what we have heard, I'm not sure what is the relevance of the issue of the child. There is a presumption of impartiality when it comes to judges. There's also a principle that you don't just bring an unfounded or unreasonable apprehension and expect that it should be granted. Judge Trope, in one of the judgments, had to deal with a situation where an accused demanded to have a black magistrate, and the magistrate who was presiding was white. And Judge Trope, on appeal, said there can never be a basis of simply feeling that you are prejudiced because you don't like the person that is presiding. So I suspect that we will see when the matter is argued. I'm very skeptical myself that this would qualify. By the way, in terms of the rules of the commission, the application ought to be filed 7 calendar days in advance. I think Mr. Zuma is supposed to appear on Monday. He would probably have to apply for condonation. But there's another important requirement in terms of the rules, is that the people who are affected or whose rights are affected will have to be served with the application and brought before the commission. And I suppose that if the issue revolves around the former partner of the Deputy Chief Justice, then she might have to be brought, because this matter will then implicate her privacy, because it's going to be ventilated in public. I'm sure she has a right to make her own representations. In that case, the ball game may change, because the Deputy Chief Justice may feel that he does not want to preside over a matter where his former partner is concerned. But I think one must also be clear that the only person who is requesting the recusal is former President Zuma, and in relation to the allegations against him. So even if the Deputy Chief Justice were to recuse himself, it doesn't impact on the rest of the work of the Commission.
Let me end off with you, Mr. Du Toit. Ultimately, the Commission seems to be saying to the former President that even if they do make this application for recusal, he's still expected to appear before the inquiry on Monday. And if he doesn't appear, then there seems to be a process with the Constitutional Court that would then be activated. These kind of things can take a long time. What do you foresee as that being the impact of that on the work of the Commission?
Typically, typically, when there's a recusal application which is denied by the presiding officer and the matter goes on review, typically speaking, it would make no sense to proceed with the matter before that very same commissioner, because there's already a ground to say this person should not be presiding over the matter. And if you then proceed and the appeal court or the review court finds that, listen, this presiding officer was in fact conflicted, it casts, of course, a serious doubt and shadow over the proceedings which were held in the absence of the High Court ruling. However, in this instance, I think we have to remind ourselves that we are dealing here with a commission. And it's a commission of inquiry, and he's just the commissioner presiding over the matter. And I think it's not a High Court trial that we are dealing with as such. And even though the test would still essentially remain the same, I somehow think that the commission might feel that, listen, we've given you ample opportunity. There's no basis, perhaps, for your application. And I'm not trying to prejudge it, but let's just play devil's advocate for a moment. There's no basis for your application, and we are proceeding because this is an inquiry. You have the opportunity of testing the water. You have the opportunity of arguing the matter. And ultimately, if you review the matter, it's going to mean that you will never appear before the commission, and that would, of course, defeat the purpose of the inquiry or the commission. So I somehow think that this matter will proceed irrespective of the grounds raised by Mr. Zuma and his legal team. And I would be really surprised if suddenly Judge Zondo recuses himself and says, well, I'm not going to preside over this matter any further. I would be really surprised.
All right, let's leave it there with both you gentlemen tonight. Thanks for your time on News at Prime.